Please call the matter.
Thank you, Judge. Caribbean Court of Justice Appellate Jurisdiction on appeal from the Court of Appeal of Belize, judgment delivery in Consolidated Appeals BZCV number 1 of 2023 and BZCV number 2 of 2023 between Merickston Nicholson and Anna Nicholson and Franziska Nicholson and Anna Nicholson and Franziska Nicholson and Merickston Nicholson. Our delivery panel comprise Mr. Justice Anderson, presiding judge.
Good morning, counsel.
Madam Justice Rajnath Lee.
Good afternoon and good morning to everyone.
Mr. Justice Barrow.
Greetings, my fellow Belizeans and all.
Mr. Justice Burgess.
You're unmuted, Justice Burgess.
I'm sorry. Good afternoon, Counsel.
And Mr. Justice Jamadar.
Good day, everyone.
May we have the appearances, please? Thank you.
May it please your honors, my name is Esteban Pereira, and I appear on behalf of Mr. Merickston Nicholson.
May it please your honors, Ashanti Martin, appearing for Anna Magdalena Ahrer Nicholson.
May it please your honors, Daryl Bradley appearing for Franziska Nicholson.
Okay, well, thank you all, counsel. Thank you for your appearances. Happy to say that we have arrived at a decision in this matter. There were 3 substantive opinions, and the lead judgment was written by my brother, Justice Jamadar, and I will now call on Justice Jamadar to read a summary of the decision. Justice Jamadar?
Thank you very much, President. First, a disclaimer. This summary, of course, is not intended to be a substitute for the actual reasons of the court or to be used in any later consideration of the court's reasons. This particular appeal concerned a dispute over land between a mother, Anna, a son, Merickston Jr., and a daughter, Franziska, following the death of their husband and father, Merickston Nicholson, the deceased. The deceased left a will which appointed his wife Anna as his executrix and made certain gifts to her and their children, including to Merickston Jr. and Franziska. The deceased gave Franziska 500 acres of land identified as parcel 302, as well as another 500 acres out of a 1,000-acre parcel known as parcel 303. Anna duly transferred the parcel 302 to Franziska, but in relation to parcel 303, she removed the deceased's name from the title and vested the entire 1,000 acres in herself and Merickston Jr., and then later transferred the entire 1,000 acres to Merickston Jr. Franziska did not receive the remaining 500 acres in parcel 303 that had been bequeathed to her. In 2018, Franziska commenced proceedings before the High Court for relief against Anna and Merickston Jr. to get the 500 acres in parcel 303 given to her under the will. The trial judge dismissed Franziska's claims and she appealed. The Court of Appeal, by a majority, held that there had been severance of the joint tenancy in respect of parcel 303. Therefore, the gift of 500 acres to Franziska was valid. Merickston Jr. and Anna appealed to this court. I authored the lead judgment and in doing so applied a gender-sensitive approach. Justices Rajnath Lee and Burgess agreed with what I had opined or have opined. And I held that the assessment and judgment of the majority in the Court of Appeal was sustainable. I was of the view that a holistic, practical, and common sense approach had been adopted by the majority, grounded in a forensic factual analysis that was tested against and corroborated by contemporaneous, relevant, and largely uncontested documentary evidence. There was no good reason for this court to disturb such findings and the conclusion that during the lifetime of the deceased, he and Anna had severed their joint tenancy in parcel 303. I noted that when historically disadvantaged groups are to be affected by virtue of the interpretation and application of statutory provisions, such as married women in the context of property rights, there arises a need for a hermeneutic of suspicion in the application of the law. Thus, deciding whether to apply equitable release under Section 38(2) of the Law of Property Act to the facts of this case, the evidence and surrounding circumstances in the case have to be scrupulously examined to ensure that presumptive social context realities are properly reckoned with and accounted for. Accordingly, and applying a gender-sensitive adjudicatory lens, if one is to conclude a release in law by which a married woman is thereby completely deprived of her rights and interests in property, the evidence must be clear, conclusive, and beyond any ambiguity or equivocation. In my opinion, there was no such evidence to justify a release by Anna of her interest in the property in favor of the deceased. In a separate judgment, Justice Anderson underscored that a joint tenancy may end by severance or release. He explained that severance may occur by the giving of notice in writing, mutual agreement, or course of dealings. The evidence of the agreement between Anna and her husband and subsequent events indicated that there had been severance of the joint tenancy during the lifetime of the deceased. Release does not require any particular form of words, but must be evidenced by settled commitment, usually accompanied by legal input on behalf of or with the knowledge of the release. Accepting and applying the principles espoused in Hudson and Hathaway, Justice Anderson found that it was entirely plausible that the equitable joint interest held by Anna had been released by her in favor of the deceased prior to the execution of the deceased's will and in accordance with Section 38(2) of the Law of Property Act. Justice Anderson concluded that the gift of Francesca in parcel 303 was therefore effective. Justice Barrow noted that Anna had denounced and distanced herself from the defense filed jointly in her name and that of Merickston Jr. Additionally, during her testimony at trial, there was a clear statement that the defense was a forgery and a fraud, and therefore a nullity. In his opinion, Merickston Jr. also had no standing to argue that the defense filed in Anna's name and in purported opposition to the daughter, Francesca's claim, did not constitute a fraud upon the court. Neither was it permissible, in his opinion, for Anna, being executrix in the deceased's estate, in litigation commenced against her in her capacity as executrix, to compete for ownership of property with the estate which she had sworn to probate. Francesca's claims, therefore, were, in his opinion, bound to succeed. In the circumstances, this court dismissed the appeals by Merickston Jr. and upheld the majority decision of the Court of Appeal. Thank you very much, President.
Thank you very much, Justice Jamadar. That is the decision of the court. Counsel, anything from you?
No, Your Honor. Thank you very much for the decision which has been delivered today.
Thank you.
Neither from us, Your Honor.
Franziska Nicholson, no, Your Honor.
Wonderful. I think you both spoke at once, but I got the essence of what you said.
Apologies.
Nothing further to add. Thank you, Counsel. Appreciate it. Well, thank you all. Madam Deputy Registrar, I think you may close these proceedings.
Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rochnertley. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Burgess. And thank you, Mr. Justice Jamadar. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you very much.